Hello, this is Lawrence Holgate, and this is episode 19 of Understanding John Locke. We're now at what I promised, to the discussion of international law and what Locke's second treatise might contribute to that. There's a controversial example of a violation of the rule of law in the 20th century, and that is the Nuremberg Trial after the conclusion of World War II, in which the victorious Allied powers put on trial high-ranking officials in the Nazi Party and government, as well as German military leaders. Although it was clear that these men had committed horrific crimes, unlawful conquests of European countries and the mass extermination of Jews, Gypsies, and other so-called undesirables, it was argued by some scholars at the time that there was no legal basis for the prosecution. According to the theory called legal-positivism, if there are no valid positive laws, that is, valid existing laws in effect, at the time an accused person committed, let's say, an immoral act, then there is no legal wrongdoing to prosecute. Hence, the trial itself was a violation of the rule of law, and the Allied powers could justifiably be called tyrants for conducting it. Sidebar: the Nuremberg Charter did outlaw crimes against humanity, but that charter was adopted after the alleged crimes took place. Prosecutions based on that provision of the charter thereafter violated the rule of law principle against the retroactive application of the law. International treaties that pre-existed World War II did outlaw wars of aggression, but they had never been enforced, thus casting serious doubt on their continued legal validity. The rule of law requires consistent enforcement of the law. But on the other side of the argument about whether the Allied powers violated the rule of law were those who cited both legal norms and natural law. The legal norms were the international treaties and agreements renouncing aggressive war and declaring it to be criminal. Both the Hague Convention of 1907 and the Geneva Convention of 1927 did define war crimes. So the accusation of crimes against humanity also could legitimately be prosecuted to the extent that they were part and parcel of the Nazi plans to wage aggressive war and commit war crimes. Finally, natural law rules placed obligation on all people to preserve and protect human life and liberty. These were clearly violated by the behavior of the officials and military leaders of Nazi Germany, and this is where John Locke clearly comes in with his theory of natural law. So any laws in existence in Germany that justified the mass incarceration and killing of Jews would simply be invalid because of their inconsistency with both established international norms and natural law. The tyrants were the Nazis, not the Allied powers who prosecuted them. And that, I think, would be John Locke's stance on this if he were asked about the Nuremberg Trials. Let's look now at section 12.3.3. By that I mean in my book, in Understanding Locke, chapter 12, section 12.3.3. It's titled Justifiable Responses to Tyranny. What justifiable response can a citizen make when the tyrant is a low-level police officer, a mid-level judge, a monarch, a president, or an international tribunal? If each of these actors, or things, has exercised power beyond what they have a right to do, is force ever an option when one confronts a tyrant? If force is exercised without right, then this puts those who are forcing and those who are forced back in the state of nature. If Locke is clear about anything, he has certainly been clear about how an individual in the state of nature can respond to force. In passages we quoted earlier, see chapter 3, 3.2, Locke writes that it is lawful to treat anyone who has me in his power. as one who has put himself into a state of war with me. Hence, Locke says, I can, quote, kill him if I can. For to that hazard does he justly expose himself, whoever introduces a state of war and is aggressor in it. Paragraph 118. But Locke does not recommend a violent response. Instead, he wants the aggrieved person to consider the status of the alleged tyrant. In the case of the police officer and the judge, the response depends on whether there is an appeal that can be made by the victim or victims of the misbehavior. Locke says in the Treatise at paragraph 207, for where the injured party may be relieved and his damages repaired by appeal to the law, there can be no pretense for force, which is only to be used where a man is intercepted from appealing to the law. End quote. So if the police officer who broke into your house without a warrant and the judge who intervened on the side of the prosecutor are reprimanded and or relieved of their duties, then there's no longer a reason to use force, for there is no longer a threat of force for you to oppose. In the unlikely event that you are not allowed to file an appeal, then Locke allows that force is still an option, although he warns that this could be dangerous and promote even more disruption in your life and in the life of others. Let's go back to King Richard II. In the case of King Richard II's unlawful act of canceling legal documents pertaining to Henry Bolingbroke's inheritance, Locke appears to give immunity to him and all other sacred princes. The person of the prince, he says, is by law sacred, and so whatever he commands or does, his person is still free from all question or violence, not liable to force or any other judicial censure or condemnation. Surprising, isn't it? Paragraph 205 in the second treatise. Locke's reason for this appears to be strictly utilitarian. Here is a long quote from paragraph 205. He says that the inconvenience of some particular mischiefs that may happen sometimes when a heady prince comes to the throne are well recompensed by the peace of the public and security of the government, in the person of the chief magistrate, thus set out of the reach of danger. It being safer for the body that some few private men should be sometimes in danger to suffer, than that the head of the republic should be easily and upon slight occasions exposed. End quote. And of course, one risks a great danger to oneself by using force against the person of the prince, even though Bolingbroke was able to capture and imprison Henry II. I suspect that he did not give Henry an opportunity to repeal his unlawful order. He was much more interested in seizing the crown than in obtaining Henry's apology. The final case involving the Nuremberg trial is much more difficult to resolve, not only because there is a clash between two legal theories, the theory of legal positivism and Locke's theory of natural law, about the relationship between law and morality, but because we are now dealing with international, not national law. The conflict, then, is between the Allied powers and a group of individuals accused of war crimes and crimes against humanity. Locke says that there is no common authority to whom the rulers of nation-states can appeal to settle their controversies with other rulers. Therefore, all of them are in a state of nature relationship with each other. The fact that these rulers, like all independent individuals, ought to conform their conduct to the law of nature does not solve the problem of how a prosecution can lawfully go forward. And this is so for two reasons. First, as Locke has insisted on several occasions, in the state of nature, quote, there is no established, settled, known law, received and allowed by common consent to be the standard of right and wrong. Locke means that unless the accused person in the Nuremberg trial agree that the natural law is a binding law, then any prosecution based on violations of the natural law would be null and void. And second, in the state of nature, there is no known and indifferent judge with authority to determine all differences according to the established law. But there is no established international law, and no judge to whom the prosecutors and the accused would give authority to decide guilt or innocence. That's the conundrum. Unless there is consent on the part of all parties in the trial about who shall judge them and how they shall be judged, any prosecution would violate the rule of law. And I believe that's Locke's stance. It may not be the stance today, but it's good thinking stuff. Think about it. Let's go to section 12.4 in my book, chapter 12, 12.4. It's called Dissolution of Government. Locke takes up the question of whether there can be a morally justifiable revolution or rebellion by an aggrieved majority of members of a political society. Locke does not use the word revolution to describe this political phenomenon. Instead, he chooses the broader term dissolution. By this he means a government that once having existed now ceases to exist, or no longer remains. There are two ways that a government can be caused to dissolve, either from without or from within. If from without, it is usually, quote, by the inroad of a foreign power making a conquest upon them. This conquest dissolves the original society that had been incorporated by the people to form one distinct commonwealth. When this society is dissolved, the government cannot remain, that being impossible, quote, as for the frame of a house to subsist when the materials of it are scattered and dissipated by a whirlwind or jumbled into a confused heap by an earthquake. That's Locke's lovely analogy. Locke says no more than this about the dissolution of government from without. I mean, what I just quoted, he says, is what happens in a government that suffers revolution or dissolution. Locke's main concern is chapter 19. In chapter 19 is to describe the causes of internal dissolution. Now, there are two ways in which a dissolution of government can happen from within. The legislature is altered. It's just broken or dissolved. And secondly, when the legislative or the supreme executive acts contrary to the people's trust. Now, that's an interesting one, because we know who seized upon that in the 18th century. And we'll talk about that in a minute. So going on now to section 12.4.1, 4.1 in chapter 12, called Dissolution by Alteration of the Legislative. In Second Treatise, Locke has frequently stressed that the legislative is the supreme power of the Commonwealth. He says, quote, it is in their legislative that the members of a commonwealth are united and combined together into one coherent living body. If the legislature or the legislative power is broken or dissolved, dissolution and death follows. Only the legislative body is authorized to make laws by the consent and appointment of the people. So Locke goes on in paragraph 212, when anyone or more shall take upon them to make laws, when the people have not appointed them to do so, they make laws without authority, which the people are therefore not bound to obey, by which means they come again to be out of subjection, and may constitute to themselves a new legislature, as they think best, being in full liberty to resist the force of those who, without authority, would impose anything upon them. Locke imagines something like the British government of the late 17th century, in which there is a monarch referred to as prince, who has supreme executive power, and a legislative assembly of hereditary nobility, and an assembly of representatives elected by the people. Locke has his readers also assume that the supreme power of the prince includes the power of convoking and dissolving the two assemblies. There are several ways that the legislative power of the assembly might be altered. First, the prince might set up his own arbitrary will in place of the laws, which are the will of the society declared by the legislative. Second, the prince might prevent the legislative from assembling, quote, in due time or from acting freely pursuant to those ends for which it was constituted. Third, the prince might interfere with the election of the legislature without the consent and contrary to the common interest of the people. Fourth, and the most damaging alteration of all, the prince or the legislature itself might deliver the people into the subjection of a foreign power. Fifth, the prince might neglect and abandon his executive power so that the laws already made can no longer be put in execution. This neglect is demonstratively to reduce all to anarchy, and so effectually to dissolve the government. Section 12.4.2, Dissolution by acts contrary to the people's trust. The people's trust, to which Locke refers, is a trust in both the legislative and the executive that they will only act to preserve the people's property, that is, their lives, their liberty, and their possessions. And to this end, the people choose and authorize a legislature who will make laws and set rules as guards and fences to the properties of all the members of society. Paragraph 222. However, both the legislative and the executive might act against the trust reposed in them by endeavoring to invade the property of the subjects, by making themselves master or arbitrary disposers of their lives, liberties, and estates. And in another long quote, this is again at paragraph 222, Locke says this: whenever the legislators endeavor to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience and are left to the common refuge, which God has provided for all men against force and violence. And it devolves to the people, who have a right to resume their original liberty, to establish a new legislature to provide for their own safety and security, which is the end for which they are in society in the first place. End of quote. Now, Locke writes that the same holds true for the prince, acting as supreme executor, who, having a double trust put to him, both to have a part in the legislature and the supreme execution of the laws, acts against both when he goes about to set up his own arbitrary will as the law of society. Thus, the prince might do in several ways, for example, by corrupting the representatives through solicitations, threats, promises, or otherwise, and then uses these promises as a wedge to influence what laws the assembly members shall enact. Locke turns the tables on the objectors when he writes that it is the prince, not the people, who is the rebel. He has dethroned himself by the arbitrary execution of arbitrary laws, and therefore put himself back in a state of nature, indeed in a state of war, with the people. They may now deal with him as they would any other man who has put himself in a state of war with them. Since the actions of the rebellious prince has dissolved the government, the people are at liberty to provide for themselves by erecting a new legislature differing from the others by the change of persons or form or both, as they shall find it most fit for their safety and good. Locke urges caution before taking up arms in a war against a powerful prince or king, surrounded by a loyal army. He says, a little mismanagement in public affairs will not arouse the people from their slumber, but repeated invasions of the people's lives, liberty, and possessions might do it. The people must wait, as did the American colonists, until, quote, a long train of abuses, prevarications, and artifices, all tending the same way, make the design visible to the people, and they cannot but feel what they lie under and see whither they are going. That's in the second treatise, paragraph 225. And even when that point is reached, when patience has run its course, when the people rise and declare their independence, it may take many years of bloodshed and extraordinary acts of courage to finally throw off the shackles of tyranny. Using Locke's famous phrase, which I talked about above, here is how the American colonists described their frustration and declared their ideals and their moral obligations to resist. Now listen to these words, because they're simply repeating some of what Locke says. Quote, this is from the Declaration of Independence. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government and to provide new guards for their future security. End quote. And with that famous quote from the Declaration of Independence, I'm going to leave you now. We have done the final chapter of my book. There are other chapters. I have a postscript comparing Locke and Plato. You might want to read that. And if you want to pick up a copy of the book, as I've said many, many times, go to my website, www.holgatebooks.com. And remember, my name is spelled Houlgate, holgatebooks.com. And there on the very front page, you'll be offered a free book, if you'd like. Not a free copy of Understanding John Locke, but a book called Understanding Philosophy. And then you just scroll down a little bit and you'll see the image of the book Understanding John Locke. Click on that. It takes you to Amazon.com. They're the ones disposing of my books, or dispensing my books. Not disposing them, I hope. They're dispensing my books, and you can get a digital copy if you want. That's less expensive than the copy with covers. So do as you wish. And it's been wonderful talking to you especially about one of the great philosophers of his time,